5. Corroboration. A fundamental aspect of biblical law appears in the commandment, "Thou shalt not bear false witness." Basic to this law is its reference to the courts and to perjury. The courts represent God's vengeance as ordered and channeled through human, but God-ordained agencies. Within the courts, for justice to prevail, honest and faithful testimony is a necessity. However, because man is a sinner and the agencies of human society reflect man's sin, checks and balances are necessary. The testimony of a witness must be subject to cross-examination and to corroboration. The law is clear at this point. One witness shall not rise up against a man for any iniquity or for any sin in any sin that he sinneth. At the mouth of 2 witnesses or at the mouth of 3 witnesses shall the matter be established. Deuteronomy 19:15. At the mouth of 2 witnesses or 3 witnesses shall he that is worthy of death be put to death. But at the mouth of 1 witness he shall not be put to death. Deuteronomy 17:6. Whoso killeth any person, the murderer shall be put to death by the mouth of witnesses, but 1 witness shall not testify against any person to cause him to die. Numbers 35:30. This law is echoed in the New Testament. Moreover, if thy brother shall trespass against thee, go and tell him his fault between thee and him alone. If he shall hear thee, thou hast gained thy brother. But if he will not hear thee, then take with thee 1 or 2 more, that in the mouth of 2 or 3 witnesses every word may be established. Matthew 18:15-16. In the mouth of 2 or 3 witnesses shall every word be established. 2 Corinthians 13:1. Against an elder receive not an accusation, but before 2 or 3 witnesses. 1 Timothy 5:19. He that despised Moses' law died without mercy under 2 or 3 witnesses. Hebrews 10:28. As noted previously, we are not under any moral obligation to tell the truth to an enemy seeking to harm or destroy us. The duty to tell the truth is reserved for normal relationships which are within the framework of law, and to the proceedings of courts of law in church, state, and other institutions. Even here, however, there are limitations on the power of the court or the demands of other persons. The biblical law of testimony does not permit torture or coerced confessions. Voluntary confession is possible, but 2 or more witnesses are required for conviction. More strictly, confession is never cited in the law. Its place in a court was apparently only in connection with corroborating evidence. Thus, Achan's confession required confirming evidence before he was sentenced and executed. Joshua 7:19-26. The voluntary aspect of Achan's confession must be noted. Biblical law preserves the integrity of the individual against forced confession. The right of citizens to be protected from the power of the state to compel their self-incrimination does not appear outside of the biblical legal tradition. The Fifth Amendment to the U.S. Constitution of 1787 embodied this protection. No person can be placed in double jeopardy. Quote, "Nor shall be compelled in any criminal case to be a witness against himself." End quote. The objection of self-incrimination means that a Christian must oppose the use of lie detectors as a matter of principle. The lie detector reverses a basic principle of justice. It is the duty of the law enforcement officials to prove guilt when a man is accused. The defendant is innocent until proven guilty. By demanding that a suspect submit to a lie detector test, this legal principle is denied. The suspect is assumed to be guilty and is challenged to prove himself innocent by submitting to that test. Another point of interest with respect to lie detector tests has been cited by a Christian police officer. An innocent man may submit to the test in the hopes of clearing himself, but once under test, his total privacy is subject to invasion. He can be asked about religious beliefs in an anti-Christian society, political opinions, does he own any guns, and almost anything the examiners choose to ask him. The result is a forced confession. Like lie detectors, wiretapping is a form of illegal invasion of privacy. It involves a form of coerced confession, a destruction of the integrity of communication, which makes it clearly immoral and wrong. There are other limitations on testimony. The right to silence on the grounds of privileged communication is to a degree granted to pastors and doctors. The presupposition in both cases is the same. The statements or confessions made by a person to his pastor or doctor in the course of a formal or professional relationship are privileged communications, because the person in question is in effect confessing to God in the form of a ministering agent. Both doctor and pastor are concerned with health, the one with physical and the other with spiritual health. Salvation literally means health. The religious nature of a doctor's calling is a deeply rooted one. Doctors were formerly monks, and hospitals until fairly recently were entirely and exclusively Christian institutions. The modern divorce of both pastor and doctor from biblical faith does not alter the essential nature of their calling. Privileged communication rests on the presupposition of the religious function of pastor and doctor as God's servants in the ministry of health. A person's relationship to them is thus not the property of the human agent, but of God. This does not deny the duty of pastor and doctor to urge a person to make restitution where restitution is due, or to urge confession where confession is due. It is their duty to uphold the law of God by urging compliance with it of all who come to them, but they cannot go beyond that fact of counsel. At the present time, there are wide variations in the legal status of privileged communications with a pastor. These differences reflect in part the theological uncertainties and instabilities of the various churches. There are other limitations on the extent of testimony. Thus, conferences with one's attorney are privileged communications, since the attorney serves as the defendant's agent and representative in court. To compel an attorney's testimony is to deny the defendant his liberty and privacy. Similarly, the spouse of a defendant is barred from testimony on similar grounds, since it would involve self-incrimination. There are exceptions to these rules under certain circumstances, but the basic principle remains true. One such exception is in cases where a husband or wife assaults the other. The normal purpose of the restriction on testimony by a spouse concerning the marital partner is not only to protect against self-incrimination, but to prevent the destruction of the marital relationship. In communist countries, the requirement that children and marital partners spy on one another is destructive of family life. There are areas of conflict over the matter of privileged communication. Corporations have largely been held to have no immunity, and their books and records can be opened. The Internal Revenue Service has regularly compelled individuals to open their records. The immunity of privileged communications has been held to apply to both civil and criminal cases, and both federal and state courts, despite some conflicts in the past. If privileged communication and immunity from self-incrimination did not exist, then corroboration, the basic premise of the biblical law of testimony, would not exist, because the routine method of quote-unquote evidences would be to force testimony out of the defendant. The law requires corroboration, because it forbids coerced self-incrimination. Thus, not only are we under no obligation to tell the truth to a lawless enemy who is bent on doing us harm or destroying us, but the requirement to tell the truth in a court of law is strictly governed by law. On the other hand, witnesses to a crime are under strict requirement to testify. As a general rule, men have a duty to give their testimony to courts of law in all inquiries where their testimony may be material, and the court is the judge of whether their witness is material. Inconvenience is no excuse. The judge and jury have the duty of assessing the value of the witness's testimony, not he himself. The court can also assess the credibility of the witness. Thus, for a long time, U.S. courts did not regard as admissible the testimony of an unbeliever, since he could not subscribe to an oath. In his own behalf only could such a person testify, and then his testimony was subject to being discounted, since the fear of God was not an essential aspect of his character. The duty to testify is a part of the citizen's police power, his part in the administration of law. Quote, "It is a general rule of law and necessity of public justice that every person is compellable to bear testimony in the administration of the laws by the duly constituted courts of the country." End quote. The duty to enforce the law is not merely a police and court responsibility, but also a public duty. The citizen is not himself the court or the prosecutor, but as a witness must serve as an agent of justice by providing such material evidences as are necessary to determine the nature of the case. The court determines their validity. Until recently, the court could also examine the witness's religious beliefs to determine his competency, because, quote, "Clearly, a witness must be sensible to the obligation of an oath before he can be permitted to testify." End quote. Until recently also, the criminal character of a man was a factor in assessing the man's testimony, although full pardon could restore competency. The details and variations are many, but the central fact is the responsibility of all non-privileged witnesses to testify. Failure to testify in biblical law means being an accessory to the crime. "When thou sawest a thief, then thou consentest with him, and hast been partaker with adulterers." Psalm 50, verse 18. Corroboration cannot exist as an instrument of justice if the citizenry is not mindful of its responsibilities in the enforcement of a law order.